Hello everyone. Does a flat nominee automatically become the owner after the owner passes away? Let's look at the answer. No, a flat nominee is not the owner of the property. Under Indian law, a nominee is merely a trustee or custodian who holds the flat temporarily for the benefit of the actual legal heirs. Nomination only allows the housing society to transfer the share certificate for smooth administrative management, but it does not override the laws of inheritance or a valid will. Role of a nominee. 1. Caretaker status, manages the flat and society matters temporarily. 2. No ownership rights, cannot sell, gift, or mortgage the flat. 3. Transfer duty, obligated to hand over the property to the lawful successors. Rights of legal heirs. 1. True ownership, legally entitled to inherit the property via a will or succession laws. 2. Full control, have the absolute right to sell, transfer, or divide the flat. 3. Priority, can claim their rightful share from the nominee at any time. If a nominee, who is also one of the legal heirs, sells or gives a flat without the consent of the other legal heirs or proper legal title, the transaction is legally defective and can be challenged, cancelled, or declared void by a court. A nominee is only a temporary custodian or trustee, even if the housing society transfers the share certificate to their name for administrative ease. Legal status of the nominee. 1. Trustee role, under Indian law, and established rulings by the Supreme Court and Bombay High Court, a nominee holds the property in trust for all rightful legal heirs. 2. No absolute ownership. Being a nominee does not extinguish the inheritance rights of other legal heirs under personal succession laws. 3. Limited power. While the housing society can permit the nominee to manage the flat or pay maintenance, the nominee has no independent title to sell, gift, or transfer absolute ownership. Consequences of selling or gifting the flat. 1. Challenge by other heirs. Other legal heirs can file a civil suit in court to challenge the sale or gift deed, seeking a declaration that the transfer is null and void. 2. Defective title for buyer. Real estate buyers and banks providing home loans strictly scrutinize the chain of title. A sale executed solely by a nominee without a registered relinquishment deed, probate, or release deed from coers is treated as having a defective title. 3. Liability for fraud breach. The selling nominee can face legal action for breach of trust and misrepresentation of ownership from the other coers.